So to go back to my proposition, I made the comment that I really struggle with the idea of inserting anything into the Constitution that provides special benefits to any individual grouping of Australians. To be fair, we need to ask the question, Marcia Langton has said that the Constitution is a racist document. What would be the basis of that claim? Because I've always thought of it as a dry and dusty document that is not racist, despite making a couple of modest provisions for the looking after by the Commonwealth, making laws by the Commonwealth for Aboriginal people. On what basis might it be seen as a racist document?
Yeah. I mean, it's partly a complex question, but in another sense there's a simple answer to it. I think on the face of the document it's not racist because it doesn't, on the whole, draw distinctions between people on the basis of race and accord special rights to some because of their race or place special detriments on people because of their race. It doesn't work that way. It presupposes that we all are citizens and that we're equal citizens, and therefore we all have an equal opportunity to be involved in politics and become members of Parliament, or nominate for election to Parliament or voting in elections and all of those things. So in that sense, I don't think it is at all racist. In that sense, as people sometimes say, it's colourblind. There is the race's power. So there's a power to make laws for the people of any particular race. But the High Court has come very close to deciding, hasn't actually finally decided, that can only be used for the benefit of Indigenous people or the people of any particular race. I mean, it could be argued that even having that clause in the Constitution is inappropriate because it's not quite consistent with the concept of common citizenship. Yeah,
it's my position that we ought to have a look at those things again and strip them out and explicitly say this is completely colourblind.
That's right.
Completely. Totally.
So there's another provision in the Constitution that says that in situations where people of a particular race are excluded from voting, they aren't counted for working out the populations of the different states when working out some of the more mechanical decisions that have to be made about representation and the referendum process under Section 128. And that seems racist in a sense, but actually what it does is it creates an incentive not to exclude people from voting. Because if the state of New South Wales was to exclude the people of a particular race from voting, then its numbers would be reduced by that amount, and therefore its representation in the Parliament would be reduced by that amount, which would weaken its voice in the federal Parliament. And so even though that on its face looks like it has a racial sort, and it is racial, it has that incentive effect of undermining racially discriminatory laws when it comes to by the states. Yeah. Now
maybe that could be cleaned up now too.
I think that could definitely be cleaned up. Yeah, and I think it should be because I don't think it's necessary, and I don't think in principle it's a good thing for the Constitution to be drawing distinctions on the basis of race. And the High Court's been very clear about this and increasingly clear about it, that the Constitution is premised on an idea about universal citizenship for all Australians, without distinctions on the basis of sex or race, for example. The Constitution evolves very gradually on the basis of the principles that are already established within it. And that creates, as I've said too many times probably to you, a certain path dependency of the steps that you take then have knock-on effects going forward. So, I mean, I would even go so far as to say that where the voice is inserted into the Constitution will make a difference. Because if it's put into a chapter on its own, it structurally gives it a significance that it wouldn't otherwise have. Because at the moment we have another institution called the Interstate Commission, referred to in Section 101 of the Constitution, but not in its own chapter. And in quite emphatic terms, there's meant to be an Interstate Commission. Doesn't exist, has existed, but it's not in its own chapter. Because when you look at the chapters of the Constitution, they reflect the important institutions of the Constitution. That's why Chapter 1 is about the Parliament, Chapter 2 is about the executive government, and Chapter 3 is about the courts. And then we have a separate chapter about the states, because they are the four important institutions, as it were. And so when you put an institution into its own chapter, you're elevating it to a status that's similar to those other institutions, even if its functions are different. So in one sense, going back to a comment you made earlier, would the voice be a third chamber of the parliament? No, I don't think it would be a third chamber in the strict sense of the word.
That was Malcolm Turnbull.
Malcolm Turnbull said that. Yeah, that's right. And I don't think it would be a third chamber in the strict sense of the word, because you have the two houses of parliament that have to legislate, and the voice is not given legislative power per se. What it's given, though, is an authority to make representations, and that has its own special dynamic. It's a unique capacity, but it's a capacity, and it's capacity different to making laws. It's a capacity different to executing the laws. It's a capacity different to what judges do when they decide disputes, but it still is a function in and of itself that's very significant, that's designed to, if it's approved by the people, shape legislation and shape executive government policy insofar as it relates to Indigenous peoples. So I think that's the best way to try to understand it. And it will be significant if it's proposed that it goes into its own chapter as opposed to a section on its own, because the structure of the Constitution is also part of its meaning. And the High Court has said that.